Hi Casey, my name is Paul. I want to say a few things about your video and what you might take as opposing what you're trying to do, and I don't want you to take it that way. The purpose of this video is, if nothing else, to perhaps warn you or advise you as to the possibilities involved or what you might have to expect. First, typically nobody wins in court, except maybe the lawyers, and you never really get justice. If you do end up as the prevailing party, don't expect much as a result, although you might be surprised. One little lady went up against the Ku Klux Klan because of their involvement in the murder of a relative and ended up owning their building and closing them down. So sometimes if you persevere, you can get some satisfaction. I want to make it clear, I happen to be a strong supporter of the First Amendment, which means I pay attention to issues surrounding it. And it's going to be a problem in your case. I believe it is legitimate to use it to protect most forms of speech. I do not believe it is legitimate to use it to commit libel or slander or otherwise directly injure someone. While I'm not a lawyer and don't presume to give you legal advice, I want you to be aware of this so it doesn't hit you suddenly and you are hurt because you're unaware of the issues. Your legal counsel may have advised you of these issues. If they have, it's good to hear that they are on the ball on this point. Otherwise, it's something I think you should know. Given that to be the case, however, the reason you have a problem is that you are what is called a public figure. I, for example, am not. At most, a few hundred people have looked at my videos, and a few dozen or so read what I say on my blog. But many of your videos have been viewed in excess of 1 million, and at least one more than 50 million times. That means you have less protection of your personal reputation than, say, I do, because presumably you've chosen to make yourself seen by a large number of members of the public. The law also presumes that as a public figure, you're supposed to have a thicker skin against attacks than a private person such as myself. If the material which is being used against you is clearly malicious in nature and defames you in some fashion, then you have grounds to sue and to get a judgment against the people doing this. However, it is possible that, as bad as this sounds, what they are doing may be considered legitimately parody or commentary about a public figure, you, that they happen to disagree with. In which case it may be protected by the First Amendment, and if you're looking to develop, say, case law to argue otherwise, you probably will not get it. And if you're looking to get some statute to do otherwise, my guess is if it is challenged, the courts would strike it down as unconstitutional. There are two cases that, if your legal counsel is good, they will be and should be aware of. New York Times versus Sullivan and Hustler Magazine versus Falwell. In Sullivan, some people ran an advertisement in the New York Times criticizing his performance as a government official. Personally, I think Sullivan picked the wrong target to sue and should have sued whoever ran the ad. But be that as it may, the U.S. Supreme Court ruled that he was a public figure, and generally attacks on a public figure have to be both untrue and either maliciously done or done with recklessness to the extent that the person either should have known they were untrue or didn't care one way or the other and said them anyway. The second item is where Hustler Magazine ran a fake ad in which it had the late Reverend Jerry Falwell apparently claiming he had sex with his mother in an outhouse. Because Falwell is also a public figure, he has to prove malice. Also, because the advertisement was clearly marked as a parody, and because of his personal reputation, the court decided that no rational person could believe what was said about him to be true. The next item concerns holding whoever posted the material liable for it, and that you may also have a problem. If the material on the websites that is defaming you is put there by its owners, then you've got someone you can target. However, there is a federal law which protects the owner of a site from being legally responsible for the content placed on it by third parties. It's called Section 230 of the Communications Decency Act. It's why YouTube is not legally responsible if one of its users posts something that defames someone else. Section 230 specifically gives the website owner both civil and criminal immunity for material posted by someone else. The website owner can't be prosecuted for libel or slander for the third-party provided material, and they're not civilly liable either. You can potentially get the username and any identifying information about the poster, but if they've used false information, you may not be able to find them. You can probably get the offending material removed by court order, and that may be where it ends. You may or may not be able to track down the people posting it, however. You may, if it goes that far, need to have technical people who can look at website logs to see where the material is posted and the IP address from where it was posted. Given that, you may be able to track back where it came from. But you need to have that information captured fast. Many places have such huge logs that they purge them every 30 to 60 days. If you wait, you may lose a means to track down whomever is posting up this material. Same for finding the computer that the material was posted from. Once you have that information, you need to track where it came from. If it's an anonymizing system or a proxy, you may not be able to go any further. If it's from a public library, they may or may not have logs showing who posted it. But if it leads to a system offering public Wi-Fi access, you're going to be out of luck finding them. But there's always the possibility whoever is doing this has not completely covered their tracks and might have left enough clues that you can nail them for it. However, if they're determined, they may keep using various methods to put this material in different places. You may need to, quote, play whack-a-mole, unquote, and keep after this stuff to get it removed wherever it is found. Again, I am not trying to discourage you. I just want you to be aware that you may have some frustrations along the way trying to go after these so-called people who are maligning you. Also note that if you do catch them and you decide to sue them or prosecute them to make an example of them, it's going to be a miserable process that is going to drag you through the mud. In view of what has happened before, you may be aware of this if you've gone through legal proceedings. If their lawyer is any good, they're going to argue that the material is not malicious, that it is satire or parody, or is otherwise valid commentary about what you've said. And it is possible a court may agree with their side, in which case you might lose. But don't let that frighten you. Be sure your side has some people with good First Amendment experience in order to know what arguments the other side might raise and how to counter them to show the material is false and malicious. Good luck to you, Casey, and my name is Paul, and that's my opinion.
Email Paul at paul-robinson.us.